when I fall, you tied a rope to me. You're blessing me every day. I was down with an illusion, like a sparrow with broken wings. But now I shine with your reflection on me. I'm getting back up on my feet. That you showed up was written in the palm. You are a statement, explode like a bomb. I get to push myself to victory. You make me winner. You cut me loose and set me free. You make me win in every way. You showed me how to spread my wings. Yes, I'm the winner of the day. You cut me loose and set.
Good evening, everyone, and welcome back to our virtual Chai Chat series. My name is Gulshan, and I'm going to moderate our today's session. And I'm very excited because we have wonderful guests, and it's our great honor to have the speakers today with us, Andrew Moore and John Rodriguez. Our guest speakers are from the United States Patent and Trademark Office, and we want to thank you for giving us your time because we know how busy you are. Let me introduce you one by one. Let's start with Andrew. Andrew Moore is an attorney advisor with the copyright team in the Office of Policy and International Affairs at the United States Patent and Trademark Office, and he's responsible for copyright issues in a number of regions around the world and serves as a member of the U.S. delegation to various international organizations. Hello, Andrew, and welcome to our virtual Chai Chat.
Hi, and thanks for having me.
Thank you. And our speaker, another speaker is John Rodriguez. John Rodriguez is an attorney in a trademark group in the Office of Policy and International Affairs at the United States Patent and Trademark Office. John focuses on trademarks and geographical indications matters across a variety of regions. He has participated as a member of the U.S. delegation team on several free trade agreement negotiations. John began his tenure at the USPTO as a trademark examining attorney. Hello, John. Thank you so much for your time and for joining us.
Good afternoon. Thank you for having me.
And I want to remind that we're live on Facebook and YouTube of the American Center Tashkent, and we want to make this as interactive as possible. So if you have questions, please post them right under this video in the comment section, and our speakers will answer them after the presentation. Again, thank you so much, and over to you.
Thanks. So I think I'm going to get started first here today talking to you about copyright issues. My name is Andrew Moore. I'm an attorney advisor in the Office of Policy and International Affairs, and the presentation today is going to be an overview of copyright fundamentals and considerations. So as an initial matter, what does copyright protect for those of you who aren't familiar with copyright? So copyright is a legal protection that provides rights for works like music, books, movies, artwork, photographs, TV shows, sculptures, and a lot of other forms of creative works, including choreography, plays, architecture, software, and what are known as compilations. So the purpose of copyright. So in the United States, in the U.S. Constitution, it grants to Congress the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So essentially what this is providing an economic incentive to authors in order to create their works. In the United States, currently at least, for works created on or after January 1st, 1978. The copyright exists from the date of creation and lasts for the life of the author, plus an additional 70 years after the author's death. And in cases where the author isn't a natural person, the copyright would last either 95 years from publication or 120 years from the date of creation, whichever expires first. So my presentation today is going to be primarily about the copyright law as it exists in the United States. Um, but there are a number of international agreements that harmonize copyright throughout the world. Notably, there's the Berne Convention, which dates all the way back to 1886. And more recently, you have things like the TRIPS Agreement and the WIPO Internet Treaties, which are the WIPO Copyright Treaty and the WIPO Performances and Phonograms Treaty. And I'll touch on these a little bit later, but primarily the presentation will be discussing US copyright law. So, what does a copyright kind of get a right holder? So you can think of this as a bundle of exclusive rights. So a copyright holder has the exclusive right to make copies of the work or reproductions, to prepare derivative works. So this would be things like making a film adaptation of a book or a translation. They have the exclusive right to distribute copies of the work, to publicly display the work, and to publicly perform literary, musical, dramatic, choreographic works, pantomimes, or audiovisual works. And for sound recordings, there's the right to publicly perform those via a digital audio transmission. So I mentioned the Berne Convention a few slides ago, and one of the things that the Convention established was that there could be no formalities, and so essentially what this is meaning is that copyright protection is secured automatically when a work is first fixed. So it's when it's created. Um, and a work is created when it's fixed in a copy for the first time. So you can think of fixation as that's when a book is first written down, or a song is recorded, or a painting is painted. Um, Once the creation is kind of fixed in a tangible medium for the first time. There's no publication or registration required, so you don't have to register your work with any kind of body in order to get protection for it. The protection exists automatically. There are certain advantages to registration. Certain, you can sue in federal court. You can get certain damages, but copyright protection in and of itself exists automatically. You don't need to do anything. So copyright infringement, this is the violation of any of the exclusive rights of copyright. So looking back at the rights we just discussed, distribution, reproduction, violating one of those exclusive rights is what's called copyright infringement. So in order for a right holder to prove or sue an infringer and prove a copyright infringement case, they have to be able to demonstrate validity and ownership of a copyright. So um, while I can sue for any of my copyrights, that I would be the right holder. And if John wrote a book and published it, and someone committed copyright infringement, I could not go sue over that copyright infringement because I'm not the owner, I'm not the rights holder, and I'm not authorized to sue on behalf of that. So you have to show validity and ownership of a copyright. You would also need to show a violation of the alleged infringer by at least one of the exclusive rights we just talked about. So if someone's doing something with a work that is not protected by an exclusive right, that is not copyright infringement. So there's a couple types of infringement. There's what's known as direct liability, and direct liability is you can think of that as the person who's actually doing the infringement. So if I am creating unauthorized copy, or I'm distributing unauthorized copies of works, I would be the infringer in that case. There's also something known as secondary liability, which is when the party who's committing the act is not the one who's actually doing the infringement themselves. So this would be, or is not necessarily the one doing the infringement themselves. So this is, there's contributory liability, which is where someone knows or has reason to know of the infringement and is materially contributing to or inducing the infringing conduct. So you can kind of think of this as helping someone commit copyright infringement. And on the other hand, you have something called a vicarious liability. And this is where someone has the right and ability to control the infringing activities and a direct financial interest in those activities. So thinking back to the copyright rights, the bundle of exclusive rights I talked about a few slides ago, those rights are not absolute. U.S. law provides for certain limitations on those rights and certain exceptions to the rights. And some examples of those include what's known as the first sale doctrine. So this is a limitation on a copyright holder's right to distribute works. And so essentially what it means is once a particular copy of a work is first sold, the right holder can't exercise control over that specific copy anymore. So if I am an author and I sell books, I sell copies of my books. Once John buys a particular copy of that book, like that's his physical copy, he can sell it. He can give it away. I can't control what he does as far as distributing that particular copy of the book goes. Now, he can't make copies of it because the first sale doctrine only limits the distribution right. But he can sell it, he can destroy it, he can give it away. Um, there are also some exceptions for libraries, archives, and teaching. Certain statutory licenses, and these a statutory license would be a license to use the work that's built into the law itself. There are certain television and radio exceptions, reproductions for those with disabilities, and the right to create a single software copy for archival purposes. The US has a particularly well-known exception here called fair use. Um, and this allows the public to make reasonable use of copyrighted material under certain circumstances without the copyright holder's consent or royalty payment. And this is in the law itself, and the law does have certain favored uses, like criticism and comment, news reporting, teaching, scholarship, or research. But those uses aren't all of the uses that could be fair use. The courts, when a court is considering whether a use of a copyrighted work is a fair use, they have a four-factor balancing test that they consider. So the first one is the first thing to consider is the purpose and character of the use, including whether it's a commercial use or a nonprofit educational use. And a lot of times, this first factor kind of gets boiled down to is the use transformative? Um, so is there a different purpose, new meaning or message? Like these kinds of things are considered in the first factor. Now, the second factor is the nature of the copyrighted work. If a work that's being used is very factual, um, that's more likely to weigh in favor of a fair use finding. If it's very like highly creative, that's maybe a little bit less likely to be fair use. The third is the amount and substantiality of the portion used in relation to the copyrighted work as a whole. So if you're thinking about how the work is used, is the person who's using the work, are they using the whole thing? Um, so are you copying an entire book, or are you just taking a small passage out of it? Um, there's no kind of set limit, like you can use 2 seconds of a song or 3 sentences of a book. That's there's no kind of hard and fast rules like that. um, it's kind of weighed under the way it's being used and how, and just what part of the work that's being used. And lastly, one of the a factor is the effect of the use on the potential market for or value of the copyrighted work. So this kind of looks at whether or not the use of the copyrighted work is acting as a market substitute for the original work. So are they competing? Is the secondary use lowering the value of the copyrighted work? Um, and not everything that lowers the value for the original copyrighted work would be necessarily infringing. You can think of an example like criticism. I could write I could take clips from a movie and write a very scathing review about the movie and why I thought it was a bad movie, and that might convince people to not see the movie. But that kind of harm on the market caused by criticism does not weigh in favor of or weigh against finding of fair use. So say you're a right holder and you file a copyright infringement suit and you win. What can you get from the court? So there are what's called actual damages. Actual damages would be the amount of economic harm actually caused by the act of infringement. There are statutory damages, which are a range of money you can be awarded that's set out, it's predetermined in the law itself. Injunctions, including temporary and permanent. A court can order the seizure of infringing copies, um, the destruction of those forfeited infringing copies, and the machines and equipment used to produce them. So, say I'm printing a bunch of counterfeit books. The court could order that all of the infringing books be seized, all the printing machines used seized, and those could be destroyed. And the court can also award attorney's fees and costs to the right holder that wins. So the last thing I'm going to kind of touch on are some somewhat recent, I guess, updates to international copyright law and how they've been implemented in the United States. So the WIPO Internet treaties, these were negotiated back in the late 90s. And it ended up with two treaties, the WIPO Copyright Treaty and the WIPO Performances and Phonograms Treaty. And the US implemented these treaties through the Digital Millennium Copyright Act, or DMCA, in 1998. And these treaties established three important obligations. So the first was the right of making available to the public. And it also established legal protection for technological measures used to protect copyrighted works. So this would be the technology that exists within an ebook that prevents you from making copies of the ebook. And also there's legal protections for rights management information. So this would be if you download a song or a photograph and the file has metadata in it, telling you information about the rights holder. So as I mentioned, the U.S. Passed the Digital Millennium Copyright Act to kind of implement these things, among some other legal protections. So first, the DMCA prohibits circumvention of TPMs, like we just mentioned. It also bans the trafficking of circumvention devices. So that would be kind of tools used to break through technological protection measures. It prevents tampering with rights management information. And notably, a violation of the TPM and RMI provisions, that's not copyright infringement. It's actually a separate independent offense. And the last thing that the DMCA does here that we'll talk about is it limits the remedies for infringement liability to internet service providers that meet certain criteria. So this limitation essentially says that as long as a internet service provider takes certain steps, they're not necessarily liable for copyright infringement committed using their services. So one part of this is a notice and takedown system. And this means that once certain types of internet service providers receive a proper notice alleging infringement, they have to take down the allegedly infringing material and notify the user that kind of posted it that it was taken down. Now that user has the opportunity to respond to that takedown notice, and they could say, this isn't infringing. I have a license or some other reason. And the ISP has to put the material back up unless they've been notified by the rights holder within a certain amount of time that the right holder has filed a copyright infringement suit over the issue. So that is, my brief crash course on copyright basics. I hope you enjoyed it. Thank you very much for watching, and please let me know if you have any questions. Thanks.
Good afternoon, everyone. My name again is John Rodriguez, and I'm a trademark attorney in the Office of Policy and International Affairs at the United States Patent and Trademark Office. It's a pleasure to be with all of you today. What I'm planning to do is to give you a general overview of trademarks, a general overview that I hope will just give you a little bit more insight as to the role that trademarks have, what purpose they have, what types of trademarks exist around the world. So let's get started here. So what is a trademark? And I pulled this definition from U.S. law, because I think U.S. law has a very broad definition as to what a trademark can be. So a trademark is a word, phrase, symbol, or design, or a combination thereof that does two things: identifies a business's goods and services to its customers, and allows customers to distinguish those goods and services from the goods and services of competitors. So basically, it comes down to trademark serving two purposes: identify the goods and services to the customers, and distinguishing those goods and services from other parties. So identifies and distinguishes. So why are trademarks important? We see trademarks every day of our lives, whether we are walking down the street, driving down the road, we see billboards, we see advertisements, watching TV, we see commercials filled with trademarks. If we're surfing the internet, we see trademarks on different web pages. So why are trademarks important? Well, they're used in identification and advertising of goods and services. Like I said before, trademarks are used to distinguish goods and services from other goods and services. So that plays a very useful role. Also, trademarks serve to identify the source of the goods and services. They tell us what company these goods and services come from. So by being able to identify where these goods and services come from, they help us as the consumer of these goods and services. They help us in reducing our search costs, because when we immediately see a good or identify a service, we identify it. We know that's the one we want. Also, trademarks play an important role in quality control. Trademarks promote customer loyalty, they build goodwill, and they encourage production of consistent and quality goods and services. So when you use a product or use a service and you're happy with that product and you're happy with that service, you want to use it again and again. So when you choose a product or you choose a service, just by identifying that good and service by the trademark, you're already realizing what the expectations will be of using that good or of using that service. So again, you know what the product will be like, you know what the service will be like. So again, it creates consumer and customer loyalty, helps build goodwill. And basically trademarks just provide quality control of these goods and services. Also, trademarks are important because they are a private property right. Once an owner is granted a trademark, their trademark is protected, they can prevent others from using that mark. That would likely cause confusion to consumers as to the source of the goods and services. So you have an exclusive right that you can use to prevent others from using that same identical or similar mark in relation to those goods and services. So again, a trademark is important because it creates a private property right. So here are just some general examples of a wide variety of trademarks. Again, as we were saying before, a trademark is used to indicate the source of a company's products or services, and they are also used to distinguish those goods and services from other goods and services. So trademarks can take the form of words, such as just the word Coca-Cola, which we're all very familiar with. They can be a design, such like a logo, such as the Nike swoosh symbol. They can be a slogan, such as "We bring good things to life." A trademark can even be a sound mark, which is a mark that you only hear. And when you hear that, you immediately realize what the services might be. A trademark could also be a color, a single color in relation to the goods and services, or a combination of colors in relation to the goods and services. A trademark can also be a three-dimensional shape, such as the McDonald's Golden Arches. A trademark can also be a type of scent in relation to the goods and services. Trademarks can be a touch mark, for example, a product having a specific type of a material placed on it could serve as a trademark. And then also we have what are called movement marks, movements that are, when you see a certain movement, they immediately bring to mind a specific good or a specific service. So basically, a trademark can really be almost anything as long as it identifies the source of a company's products or services and distinguishes those goods and services from other goods and services. So here are just some more examples of different types of marks. And here are what we refer to as design marks, which are just basically logos. For example, we have here the Nike swoosh symbol, the McDonald's Golden Arches, the logo for Apple computers, the logo on the right corner for Microsoft. Under Armour is there, as well as the logo for Yahoo Internet Company. So again, these are just examples of design marks. And as we were saying, trademarks can also be slogans along with designs. And here we have some examples of those types of marks. For example, Nike has the slogan, "Just do it," along with this particular design. McDonald's has the slogan, "I'm loving it," along with this design that you see here. Coca-Cola has a slogan, "Always Coca-Cola." KFC, which I think we're all familiar with, has the slogan, "It's finger licking good," along with the logo you see there. Burger King, again, another familiar trademark, has a slogan, "Have it your way," along with its logo. And then Nokia, the cellular phone service company, has a slogan, "Nokia, connecting people." Again, these are just some examples of slogan marks, or marks that consist of slogans with a particular design. And then here are examples of marks that consist of words and a design. For example, Nike and its swoosh symbol, Pepsi and its logo, the Starbucks coffee logo, the McDonald's logo, and a design and word for Coca-Cola. So again, these are just different examples of different types of marks. And as I mentioned, trademarks can even be for a single color or a combination of color in relation to the goods and services. So UPS, United Parcel Services, which is a package and delivery service, they have a trademark for the color brown in relation to package and delivery services. So they apply the color brown to their trucks, as you see here. They apply brown to their uniforms. They apply the color brown to their airplanes. They use brown, the color brown, in their advertisements. So again, UPS has kind of latched on to this color brown in relation to these particular services, package and delivery services. Tiffany's is a store here in the US. They also have a color mark for this variation of blue. It's referred to as Robin's Egg Blue. And they use this particular color on boxes. They use this particular color blue on bags. So when you see a person, for example, walking down the street carrying a bag with that's this particular color, then you immediately brings to mind Tiffany's. So in that way, this particular color is serving as a mark because it's used to identify the service, the store service, or the goods for Tiffany's. And as I was mentioning, there can also be motion marks. And this is usually marks that consist of motion. And here's a great example. When you go to the movie theater, and usually in the first 3 to 5 seconds of the introduction of the movie, if it happens to be a movie produced by Columbia Pictures, you will see this frame about this moving image of the sun behind the statue, the clouds parting. That 3 to 5 second frame is a motion mark owned by Columbia Pictures. So even if it didn't say Columbia, but you saw this moving sun behind the statue and the clouds parting in relation to movie services, then you would immediately recognize this movie being produced by Columbia Pictures. Trademarks can also be shapes. So trademarks don't have to be words or slogans. They can also be three-dimensional shapes. And probably one of the most famous three-dimensional shape trademark that we have is what you see here in the center of the slide, the shape of the Coca-Cola bottle. You immediately recognize this shape as a Coca-Cola bottle without any wording, any slogans, just due to the nature of the shape itself. And so that aspect, the shape is serving as a trademark because, again, it is used to identify the goods and distinguish those goods from other soft drink goods. And here are some other examples of three-dimensional shapes. For example, there's a triangular chocolate called the Hershey's Kiss. This chocolate company has a registered trademark in the US for the triangular shape of it. Here on the bottom right corner, you see a unique design of bottles for pomegranate juice. You see also a particular design for whiskey bottle. You also see a three-dimensional shape for the building of the McDonald's fast food company. This is a famous shape that if you were just driving down the road here in the US and you didn't see any signs or wording that said McDonald's, but you just saw the building itself, it would immediately bring to mind McDonald's. So again, the shape of the building is serving as a trademark because it is being used to identify the goods and distinguish those goods from other competitors. So I did want to show you this chart here. And this is basically what we refer to as a spectrum of distinctiveness. So every trademark falls along, can be placed on the spectrum. We have basically two parts of this chart of the spectrum. We have marks that are considered inherently distinctive and marks that are considered not distinctive. So for a sign to serve as a trademark, for a slogan to serve as a trademark, for a word to serve as a trademark, we want that sign, that slogan, that color, we want it to be distinctive. If it is distinctive, then it is fulfilling its function as a trademark. So on the left-hand side of this chart, you have what are considered to be coined and fanciful trademarks. And these are trademarks that were created for the purpose of serving as a trademark. These terms, these words never existed before. but they were merely created for the purpose of serving as a trademark. So, for example, the word Exxon, it's not a word in the English language, or the word Kodak. It's also not a word, an existing word, but it was merely created to serve as a trademark. Kodak was created to serve for film, for cameras, and obviously Exxon, we know is being used for the petroleum industry, for gasoline. And then moving along the spectrum here, we have arbitrary terms, and those are terms that did exist already in language, but they are being used in a very distinctive manner in relation to the goods and services. So, for example, the word camel. Obviously, the word camel is a word in the English language, but in relation to cigarettes, Camel is a brand of cigarettes. It is a trademark of cigarettes. And then we have terms that are suggestive. And these are terms that are still distinctive. They are still inherently distinctive, but they require some additional thought as to what precisely are the goods or services. But again, these are great, all these types of terms, coined, fanciful terms, arbitrary terms, suggestive terms, are all considered to be inherently distinctive. Then crossing over, moving down the spectrum, we come across those terms that are considered not to be distinctive. These are signs that really are not serving the role of being distinctive. Again, we want marks to be distinctive. So we have terms that are merely descriptive. These are terms that merely describe the goods or merely describe the services. Those generally are not able to be protected as trademarks. There is a caveat there. If a company is using a merely descriptive term in a way where the public starts recognizing it as being distinctive after a certain period of years, maybe they did a lot of advertising, again, where the general public starts seeing this term as no longer just being merely descriptive, but actually having a distinctive role, then there could be a possibility of that sign being registered due to it having acquired distinctiveness. And then obviously at the end of the spectrum are terms that can never be protected as a trademark. These are those terms that are generic in relation to the goods or services. These are the common names of the goods and services. For example, the word apple cannot be registered or protected as a trademark in relation to the apple fruits. The word milk cannot be protected or registered as a trademark in relation to milk products. Again, these are the common names of the goods and services, and they are not able to be protected as trademarks because they are considered to be generic. I did want to go over quickly, just for your information, what the stages are for getting a trademark registration. And I approach this slide just from a very high level. These are the different points that an IP office, a trademark office, will have in order to get a trademark registration. Obviously, you need to submit an application to the IP office. There will be an examination of the application according to the country's national trademark laws. There will be a publication of the application details in order to give notice and inform third parties of what precisely is in the application. Generally, there has to be an opportunity for interested third parties to oppose the application. And then after opposition, generally the registration certificate is issued. And also there has to be an opportunity to cancel the registration once it has issued. And then some countries also have some maintenance requirements. For example, you might have to show that you are using the trademark in relation to the goods and services after a certain number of years. Or a trademark registration Generally, will be only for a limited amount of time, usually about 10 years. Most offices have a term of 10 years. So if you want to maintain that registration, you will have to renew that registration. And then just to conclude here, I did want to give some information about why we do tout the U.S. federal trademark registration system. We do encourage businesses, companies, anyone who is interested in getting a trademark to pursue a federal trademark registration at the USPTO. There are several advantages of having a U.S. federal registration. By having that federal registration, you give public notice that you are the owner of that mark. Also, there is a legal presumption of ownership of that mark, and also a legal presumption that you have the exclusive right to use the mark across the entire U.S. Also, by having that federal registration, you can access U.S. federal courts. You can also use that federal registration certificate to obtain registration in a foreign country. You can also use the R circle symbol that we frequently see. And then also, once you have a federal registration, that information will be entered into our PTO, USPTO online database of pending applications and registered marks, and it will come up in our examining attorney's search for any conflicts. And then a U.S. federal registration may be recorded with U.S. Customs and Border Protection to prevent the importation of infringing foreign goods into the U.S. So again, we do encourage the registrations, federal registrations at the USPTO here in the U.S. So that's what I have for you today. Thank you again for having me. I hope my presentation was informative and useful to you. And if you have any questions, I'm happy to take any questions now. And I think I will turn it over to Gulshan.
Thank you so much, John, and thank you, Andrew. It was so informative, and I think our viewers have received a lot of new information from you. We do have some questions here. So let me pull up the first question. From Abdullah Erkinov, he's asking, I'm a student and I can't afford buying certain books. Can I print out the PDF versions of those books and use them?
I can take this one. You know, it's hard to say. It would depend on the where the PDF version came from and the license of that came with the book. So it's hard to say. I would say, you know, make sure that you're getting authorized copies of books. It's hard to say specifically in that circumstances. I know some publishers will sell and distribute PDF versions, but I can't say for sure how widespread that practice is or where you're finding PDFs and whether or not they're legitimate. Sorry, I can't provide any concrete answer to that.
Mm-hmm. Thank you. Radmila is asking if there will be a recording of the chat. Yes, Radmila, the recording will be on YouTube and Facebook, and you can go back and watch it when you have free time. Next question is from Dania Hasanova. She's asking, how long do trademark and copyright protections last?
For copyright, it is the life of the author plus 70 years, at least in the United States. So the whole life of the author plus 70 years after the author dies. And if you're not a natural person, so say it's like a legal entity that owns or that created the work, that would be 95 years from when it was published, or 120 years from when it was created, whichever expires first.
And then I would say for trademarks, in the US, a trademark registration has a term of 10 years, but it can be renewed indefinitely. So a trademark owner, if they so choose, can have their trademark registration last forever if they so choose to do so, and as long as they keep renewing it every 10 years. And I think most countries generally do have a 10-year term. There may be a few that have maybe 7. 7 is the minimal. There's an international treaty that refers to at least 7 years. But most countries that I'm familiar with will have a term of 10 years. But it can be renewed indefinitely and last forever.
Thank you. There are some questions coming to us from Telegram. What are the requirements of a good trademark?
Yes, the main requirement is that it be distinctive. So make sure that it is not describing your goods and services. You want your trademark to kind of stand out, to be unique. You don't want your trademark to be confused with any other already existing trademark. Maybe a unique color scheme, but you want it to be unique. You want it to be distinctive, and you want it to be a sign that people, when they immediately recognize, when they see the mark, they'll say, "Oh yeah, that's the company that has these types of sandwiches," or "This is the company that provides this types of service." So a mark that again that easily identifies the goods and distinguishes those goods or services from other goods and services.
Thank you. Our next question is from Abdulmumin Yuldashov. Thank you, Mr. Moore, for the informative presentation. I have 3 questions regarding copyright system in the US. I know that in the USA, there is a system of voluntary registration of copyright objects. If the author of copyright holder registers his works, what privileges does this procedure give?
So the benefits of registering your work in the United States. So first, it puts others on notice of your copyright claim. Your rights will be entered into online databases with the U.S. Copyright Office, and so when people search, it's in there. It's required to file suit in federal court for works of U.S. origin. American-made works have to be registered in order to sue in federal court in the United States. It provides what's known as a prima facie evidence of the validity of a copyright and the facts on the certificate if you make it within the first 5 years of publication. So that's basically, as long as you register it within the first 5 years of publication, if you go to file an infringement suit, you can just kind of bring the copyright certificate, and the court presumes that information is correct. It can be proven wrong, but the copyright certificate goes a long way. The registration can also be recorded with U.S. Customs and Border Protection in order to prevent to help prevent importation of pirated products. Statutory damages and attorney's fees can be available in litigation, but only if you register it or if the registration is obtained within 3 months after publication of the work or before the infringement of the work. And it also just kind of generally makes it easier to license the work, collect royalties, and enforce your rights outside of court. If you can kind of take your registration to people and say, "Look, this is mine." So those are kind of the main benefits to registration.
So the second question is there any percentage limit in the US for the use of copyright works for scientific purposes without the permission of the author, rights holder?
So is there a certain amount you can use for scientific purposes before it becomes copyright infringement?
Right, before you
No, there's
ask for
no
permission.
set. Yeah, there's no set limit. If your use doesn't fall within any certain like exceptions or licenses, or um, it could the use could be fair use, but that's very fact specific. So it depends on the exact circumstances of how you're using it. But the short answer is no. There's no percentage limit. Sometimes a tiny bit of use would be problematic. Sometimes using the whole thing is fine. It really just kind of depends on the circumstances.
Thank you. And the third question is there a mechanism for holding a user liable for the use of unlicensed resource in digital copyright law in the United States?
So is there a mechanism for holding a user responsible? Basically, like if someone, like a user, uploads infringing content, is there a mechanism? Yeah, any of you could file a lawsuit against them. That's any of the remedies available outside the digital space. You know, Filing lawsuits, the injunctions I talked about, those all apply to users in the digital space too. There's no separate set of rules and procedures there. The one main thing though being that the service providers themselves, so not the users, but the service providers have uh, some limitations on their liability.
Thank you. Next question is from Dania. How can people register copyrights and how long does the process take? Thank you.
In the United States, copyrighted works are registered with the U.S. Copyright Office. So if you go to copyright.gov, that has a whole bunch of instructions on you can e-file your copyright there. I can put that in the chat. The current registration times, I think, are for if you file electronically. I think it's about a month. If you It can take longer if you have to mail in your deposit. So when you register your copyright, you have to provide a copy of the work itself. If you have to mail that in, a physical deposit copy, it takes longer. I think it takes 10, 11 months, something like that. But the typical copyright registration currently, I think it's about a month.
Right. Thank you. Let me look at the questions. Can there be more than one owner of the trademark?
A trademark owner, you can have joint ownership amongst different parties. So that is a possibility. But that joint partnership would be the exclusive owner of the trademark. And that would be the only situation. But what we're trying to avoid with trademark, because there is an exclusive right that is attached to trademark, once that exclusive right is granted to that entity, a second entity would not be able to come along and get a registration for that same or identical trademark. So that's how we would handle that situation.
All right, thank you so much. I don't see any questions so far. Should I pull up the PowerPoint?
Sure. Great. So I think these are some examples of some perhaps some problematic uses of trademark. So we see here in the bottom right-hand corner the Apple trademark that I think we're all familiar with. With the logo and the word Apple. For the phones, for computers, for things like that. And then we see what perhaps could be, we're not sure yet, but it could be a problematic use. The word apple.uzb And if this sign is referring to the sale of electronic goods, of phones, of computers, that could be an issue. That would be an issue because that would be misleading and confusing people to think that this website is associated with the Apple company. But again, perhaps, not having more information about what's being sold at this website. Maybe it's a fruit stand, maybe it's a fruit stand underneath that happens to be selling apples. That would be okay. But again, the issue would be if apple.uzb was being used to sell phones, computers, laptops, things like that. If they were in a way trying to confuse people to think that they are associated with the Apple company, then that would be a problem.
Mhm. Okay, next one. Oops. Sorry.
Here's a great example of a concern. So on the right-hand side, we have the product for Pantene shampoo, which is spelled P-A-N, take my glasses off, T-E-N-E, which is the legitimate product. And you see the color, you see the different elements of the packaging of the product, which creates the look and feel of the product. So you have that. And then on the other side here, the picture, you have Pantene spelled with an I, P-A-N-T-I-N-E. And it is using, similar colors, the golden color. So again, this would be a problem because it appears that there is an effort to confuse and mislead people that the packaging on the left is either coming from the same company as the legitimate product, the Pantene shampoo company. And that is an issue because when you have products like this, especially personal care products, it can be there can be health risks because you're not sure what the ingredients are. There could be some, who knows what might be in this envelope that's appearing to be shampoo, trying to pretend that it comes from the Pantene company. So again, this would be an issue here. Again, and then here's another great example of confusion. On the right-hand side, we have Burger King, its design, its color scheme, the way the words appear, and the font and the color. And then we have on the left-hand side, King Burger, where the words are just transposed. And also they appear to be using the same color scheme as legitimate Burger King. So again, this appears to be an issue here where they're trying to confuse people into thinking that there is an association or that this company is related to the actual legitimate Burger King. On the right-hand side, you see Dunkin' Donuts, the coffee company, and they have a trademark for the words Dunkin' Donuts. They use this particular color scheme, the way the wording appears, those unique colors. And then on the left-hand side, you have something that says Sweet Donuts. Again, appearing to use the same type of lettering, the same type of colors. So there could be, again, without having more information, there could be an issue here. But the fact that they are using the same color scheme, the same type of letters, there could be, again, without having more information, there could be an issue here where they're trying to create a connection with the real Dunkin' Donuts. And then Subway, you have the Subway logo on the bottom here which uses yellow and green as its trademark. And then on the top here, you have a questionable sign for Subway. Instead of green, it's using red. Again, we would need to have some more research. This could be an instance where there is someone trying to confuse people that there is a Subway sandwich shop, a legitimate one, at this location. I'm not familiar if Subway may have other color schemes besides yellow and green. If they don't, then this could be an issue where, again, there is an attempt to confuse and mislead people into thinking that this location is associated with the well-known Subway sandwich shop. And here it looks like there are efforts to use well-known marks on packaging. These are all characters in different movies: Harley Quinn, the Joker, Suicide Squad, Rick and Morty, SpongeBob SquarePants. Again, looks like these are instances where there are where they are using names of well-known characters from movies on packaging. And if there is no clear authorization, this could be an issue as well. We have the familiar golden arches with McDonald's on the right-hand side. It looks like there's someone might be using the same look of the golden arches for. I'm not sure what that's referred to as hamburger, but again, there could be an issue here. So again, looks like they are trying to use the well-known arches, golden arches, as part of its logo. So there could be an issue here as well. On the right-hand side, you have the shampoo head and shoulders, with its distinctive shape of the packaging, the colors that it uses on its packaging, and then on the left-hand side, we have what appears to be similar words: Heldress shampoo. Again, using similar colors, trying to create the same look and feel of the legitimate product. Again, there are risks here because you're not sure what is found in this concerning product. So again, there's likely an issue here.
Thank you so much. This was the last slide from Uzbekistan. So I think it's time to wrap up, but it was very, very informative. Thank you so much. We learned so much about intellectual property rights today. And we hope we will be able to meet you again and probably hear some more information about it, because we do need it here in Uzbekistan.
Well, thanks so much for having us. It was a good time. Thanks.
Yes, thank you for having us. See you soon.
Thank you. Thanks everyone for joining us.
Bye.
Thank you for questions, and join us next week for Virtual Chat Chat. Bye-bye.
Take care. Bye.